Class?
Now that I recall it, not at all. He was a very, very nice teacher towards me and the students, and also counseling. If he would ever do something like that, it would, like I said, be indirect, and no, he would never mention anything personal.
And when did you start noticing these behavioral changes in Mr. Brooke?
More recently, actually, in the past 2 weeks, I'd say. Like I said, more aggressive, especially towards students. Whenever I ask a question, he'd be not very clear with the answer, and just on edge.
But before this, he always been more calm and cheerful person.
Very calm, yes, funny doing that.
Really? So, in your opinion, you would say behavior, would you say he was one of your favorite teachers? In that case?
Favorite?
Objection, Your Honor, relevance.
Please continue.
What is the relevance of him being the favorite teacher? I don't really think that has anything to do with the verdict.
Counsel, please state relevance.
Well, getting to know his favorite teacher may show him if he's the better person.
I cannot.
Objection sustained. That doesn't really show relevance if it's his favorite teacher as opposed to just a teacher in the school. Please proceed with a different line of questioning.
When Mr. Brooke, in your opinion, perceived to be murdered?
Objection, Your Honor. Hearsay.
Leading questions are not permitted for opposing counsel witnesses. If I have to remind your counsel again, there will be penalties, so please continue with a different line of questioning.
Well, that's it there. Thank you.
Would anybody else from the defense's counsel like to proceed with questioning of Mr. Zems?
Yes. Wait a second. I forgot my question. So you said for the past 2 weeks, Mr. Brooke was behaving erratically towards students.
Yes.
Do you believe that the fact that maybe he's on trial for murder would have contributed to the fact that he was stressed out?
Objection, Your Honor. The timeline. The witness previously stated that it was leading up to summer break, and Mr. Brooke did not go on trial up until after because he committed the murder in July.
I was here as well. I did not hear him say leading up to summer break. Objection
It was
overruled.
in the actual deposition of the witness.
There was no deposition conducted in this trial. Objection overruled. You may proceed with questioning.
Right. Could you answer our previous question?
Would you be able to restate it for me?
Do you think the fact that Mr. Brooke had been on trial for murder might have played into the fact that he was stressed and maybe that's why he was acting erratically?
Well, of course, during the time of this trial, I had no idea that he was on trial. Since also, I said, I didn't really know anything about his personal life, as he didn't mention anything about his personal life. So the only thing I did know about him was obviously that he murdered someone.
Earlier you had said,
Excuse me, counsel. For clarification of the jury and for myself, when did the unusual behavior begin? Before or after the incident?
Before.
And just to be clear, that is before the murder of David Bennings.
Yes.
Okay, that is just for clarification. You may proceed with your line of questioning. Oh, sorry. Mistake on my part. The death of David Bennings.
good point. If you just told our honorable judge that the behavior started before summer, why did you tell my colleague the behavior started 2 weeks ago?
2 weeks ago, or 2 weeks before the murder.
I'm not sure what you're referring to, that's why I'm not.
Objection, Your Honor. He's a 16-year-old.
What relevance does that have to the case? Silence! What relevance does that have to the case?
She is a lawyer, and she appears to be leading the witness and trying to trip him up, guilt trip, not guilt trip. What am I saying? She seems to be trying to confuse the witness and trying to lead the witness.
I think the witness is confused as well. There is a very blur between the timelines right now, and the line of questioning is making it more confusing, I believe, for myself and for the jury. If the witness would please like to elaborate on the questioning, if they so choose. Elaborate on the timeline.
Yes, for sure. When I refer to 2 weeks, I refer to as in 2 weeks before the murder actually occurred, not 2 weeks before this trial or anything else.
Thank you. I think that is enough questioning about the timeline for this witness. Is the defense done questioning this witness? Yes, Your Honor. Mr. Zeman, you may have a seat. Thank you. Are there any other witnesses that either counsel would like to re-examine or any more
Excuse me, Your Honor.
witnesses? Yes?
The Crown would like to recall Ms. Sandra Volsky to the front.
Ms. Wolfie.
Please state and spell your name for the
Guys,
record.
hold on. So she's already sworn, so what happens now is the judge just reminds her that you are sworn.
She's went through his graphic paper, Your Honor.
Counsel, could you please question this witness appropriately in an appropriate manner?
So,
Please have a step back and maintain appropriate distance from this witness. Sarcasm is not tolerated by court.
Sir, this is more than a fair warning. One more and you're out.
Now, I was
You may continue questioning.
so again, as Officer Lowe said, she could not see anything up at the balcony, and she wasn't drunk. So how do you believe the members of this fine jury to believe that you could see that when you were drunk?
I wasn't drunk. I never said I was drunk. I was below the legal limit. I had one sip of wine that night. I was feeling a little lightheaded, but I could still think clearly and see clearly and hear clearly.
For clarification of the jury, proceed with questions.
Your Honor, in the previous session of this court, and gentlemen of the jury, in the previous session of this court, Miss Bonnie Brazier said that she felt dizzy. Not just a little lightheaded or a sip of wine, she felt dizzy. I would also like to remind all members in this courtroom that there was no drug test conducted of Miss Brazier, so she could just be full-on lying.
I'm not allowed to lie in a court of law. I would never.
But you do love your fiancé, don't you? You are engaged to him. You are to be married to him. You do love him, don't you?
Yes.
Would you do anything to save his life?
Objection, Your Honor. He's still leading the witness to try to say something he wants him to say.
Objection sustained. No leading questions are permitted to the opposing counsel's witness, as we have discussed several times throughout this trial. And you seem to continue to move closer and closer to the witness. Could you please have a step back, sir? Thank you. You may proceed questioning.
So I ask you again, would you do something to help your fiancé if you saw that he was in trouble?
I would do something if I believe he's not guilty.
And in this case, you believe he is guilty?
Of course not.
The Crown rests its questions. The Crown rests its questions.
Thank you. Ms. Brazier, you may have a seat. Here's some more paper. For the jury's clarification, I would like to call up Sandra Volsky to the stand.
And the judge can't call forth another witness if questions from the jury do so.
Ms. Volsky may have a seat. You can sit as well. The council has sat as well.
Hey,
Excuse me, I can hear that from here.
Thank you, Your Honor. The system needs change. The system needs work. As soon as our people that are required.
The council needs work. Okay.
That's the system.
okay, hang on, all right, so you got
Whose courtroom is this? Please stop speaking out of turn. Sir, thank you.
Can I take him out?
No, he is representing the Crown. So, Ms. Volsky, a question from the jury. Since the victim is deceased, was the victim involved in criminal activity? Can you testify to that? Thank you. Jury, does this clarify any doubts?
We're just wondering, the defense of narcotics, how did the victim acquire narcotics?
So how did Mr. Bennings acquire narcotics? How did they more specifically reach your apartment in this situation?
I'm not sure, he did not share that with
Your Honor, if I may,
Yes.
the narcotics found were cannabis, and in Canada, cannabis is a legal substance.
If you read the evidence properly, it says marijuana and narcotics. So there were other substances found as well.
Yeah, Tylenol can be classified as narcotics, so I think.
I don't think Tylenol will be found in an ashtray. Overruled. Does the jury have any more clarifying questions for Ms. Wolski?
No, Your Honor.
Ms. Wolski, you may have a seat.
Pause 1 second. Is there anybody here who has to leave for anything to review?
Sir, can you just quickly let Mr. Penner know?
The jury has another question? I would like to call Wally Road up to the stand to clarify the jury's question. May I have a seat? Mr. Brogan, I believe that you're aware that you have sworn into oath yesterday, so everything that you say must be the truth or there will be consequences. So the jury is asking, how does the accused yourself believe that the victim framed your brother?
So how exactly he framed my brother? Well, in fact, you can say that he had trafficked these narcotics, and he was an associate. My brother was an associate with Mr. Brazier, and Mr.
Just for
Objection.
who is Mr. Brazier?
Not Mr. Brazier, sorry.
If you need a minute to think.
Do you want the script? Yeah, it's okay. Take script and remember names. It's okay. So this is not quite a mischievous place. Take that a quick look. Very simple.
Mr. Benning, so, Mr. Benning. Okay, yeah, Mr. Benning, correct. He wanted my brother to stand on trial for it, and my brother didn't want him to, and apparently one of his, another associate ratted him out saying that my brother did all of these sorts of things. And I knew that Mr. Benning had orchestrated this, so I attempted to try to talk to him, convince him, tell him that the testimony that his associate gave him was a lie.
Okay, so just to clarify for the jury, you're saying that it was due to communication with the associate that your brother was framed of trafficking narcotics? Okay, thank you. Does either the defense or Crown like to cross-examine this witness while we have him here on stand?
Yes, Your Honor, we would like a question.
You may proceed.
So, Your Honor, I'm having a little difficulty with the evidence because Mr. Grove said that his brother went on trial for Mr. Benning's dealings. But I'd like to first remind the jury that I'm not sure if he can speak on that because he wasn't there. And second of all, it seems like hearsay. But yeah, there's no case of your brother in the evidence that says as such.
Wasn't present in the evidence. And also, my brother informed me of this whole ordeal.
So again, it's hearsay. You admit it's hearsay.
If need be, you are allowed to call up his brother to stand instead of questioning this witness directly.
Because, Your Honor, he did say that his brother was dealing with Mr. Bennings, but again, he wouldn't know that because he didn't speak to his brother since college.
Absolutely not. It's absolutely not. You've got
Your
all
Honor,
the
that
evidence
is
in
not
your
true.
Yes, go ahead.
So, you specifically said I haven't talked to my brother since college. However, in my brother's witness statement, he says that I've had to see him once a month, and we did something activity once a month. If you heard that correctly, then you would.
Sorry, counsel, just to clarify, your own witness, Peter Promise, was there to testify that his brother and him had a discussion the day prior to the incident. So please get your own facts in check before questioning
He's spoken since college until his brother went to jail.
Your Honor.
So why did you not clarify that when you were questioning him?
Because I tried to, but the witness kept interrupting me.
The witness has the right to speak just as much as you do.
Your Honor, I believe we should all be able to speak without interruptions.
Or maybe you should stop interrupting the witness. Would you like to proceed with a clearer line of questioning?
Your Honor, the Crown rests its case as actually one more question. Your defense team said that you committed the murder.
Well, that might have been
As is a judge.
misinterpretation of words and misinterpretation of language. Miscommunication doesn't mean anything about the actual case. It has nothing to do with anything that he said. You have to discuss with my lawyer about that, not me.
To clarify, his lawyers are not on trial. He is.
Yes, and his lawyers admitted that he committed the murder.
Your Honor, there's a clear miscalculation.
There's this thing called a Freudian slip. It's when you say something that you truthfully mean, but you don't want to say. Now, that's what I think. I think
Counsel,
that's professionals
counsel,
would have-
his lawyer
On the count of first-degree murder, the jury finds the defendant not guilty. On the account of breaking and entering, the jury finds the defendant not guilty. On the count of assault, the jury finds the defendant not guilty. On the account of mischief, the jury finds the defendant not guilty. On the account of uttering threats, the jury finds the defendant guilty. On the account of damage of property, the jury finds the defendant guilty.
Thank you. So the jury has found the defendant guilty for damage of property and other threats. So there will be time served and a fine. The fine is up to $2,500, and the time will be served for 6 months. Sentencing will be done immediately. You may proceed. Thank you.
Take him to jail.
Please put your hands behind your back.
You will serve your time in Toronto Penitentiary.
Slam him down.
You prisoner. Go to prison. Rotten hell, you.
Well done.
Thank you, Your Honor.